Christina Voigt. I'm professor of law at the University of Oslo, and I work primarily in international environmental law. I am also the chair of the Climate Change Specialist Group of the IUCN World Commission on Environmental Law. In my lecture today, I will talk about the role of climate law from a European perspective. And in doing so, I will first say a little bit about the scientific background on climate change and where the world needs to go within the next 10, 20, 30 years. Second, I'll give some examples of climate change legislation here in a European context before I'll turn to climate change litigation and give some examples of climate change cases that are currently being heard or have been heard at different courts here in Europe. And finally, I'll offer some reflections about the role of law in addressing climate change and in bringing about social change. Now, when we talk about Europe, the European perspective, I just want to remind the audience about the fact that not all European states are members of the European Union. We have, of course, all 27 member states, but also Norway, Iceland, UK, and Switzerland are counted into this European context without being members to the European Union. It's just as a backdrop information. Okay, so where do we need to go? Where does Europe need to go? Where does the world need to go? And of course, the legally binding treaty that we're all looking at when discussing this question is the Paris Agreement, which was adopted under the United Nations Framework Convention on Climate Change in 2015 and entered into force and record speed less than a year later in 2016. And the Paris Agreement in its Article 2 sets very clearly out that its purpose is to strengthen the global response to the threat of climate change. And then it sets out several sub-goals. And one of the most talked about and famous and most important goals of the Paris Agreement is laid down in Article 2, first paragraph, where it says that the agreement aims to address the threat of climate change, including by holding the increase in the global average temperature to well below 2 degrees centigrade, above pre-industrial levels, and pursuing efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels. This goal set out by the Paris Agreement is a very crucial one, but it is not yet very concrete what exactly needs to be done in order to keep temperature increases somewhere to 1.5 degrees and well below 2 degrees centigrade. Now, in order to become more specific, the Paris Agreement also has an Article 4, which deals with mitigation, which is reduction of greenhouse gas emissions and removals, increase of removals. And the first paragraph of Article 4 says very clearly that in order to achieve the long-term temperature goal, which was set out in Article 2, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, recognizing that peaking may take longer for developing countries, and to undertake rapid reductions thereafter in accordance with best available science, so as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century. Now, this reference to best available science is the hook in the Paris Agreement to draw in the latest findings by the Intergovernmental Panel on Climate Change, the latest reports. The IPCC does not carry out scientific research itself, but it assesses the status quo of science worldwide. And that reference to in accordance with best available science is the invitation to interpret the Paris Agreement in light of the latest reports by the IPCC. And the IPCC has been very, very clear recently on what it means to keep temperature increases to 1.5 degrees. In its special warming report from 2018 on global warming by 1.5 degrees, it stated that it is still possible to keep global warming to 1.5 degrees. pathways exist that could keep global warming to that or below that threshold. But it also says that in those model pathways, with no overshoot of 1.5 degrees, global net anthropogenic CO2, carbon dioxide emissions need to reach net zero around 2050. And that's a very, very important and a very concrete finding. It basically says by 2050, all CO2 emissions have to be balanced out. They have to be reduced as much as possible and balanced out by removals in order to reach a global net zero sum by 2050, which is 30 years away. In order to keep global warming above 1.5 degrees, but well below 2 degrees, we have a little bit more time until 2075, but the trajectory is exactly the same. And the IPCC also says that the longer we wait with reducing emissions, and the more we emit in the meantime until 2050, the more we have to get to negative emissions after 2050 in order to keep temperature increases somewhere close to 1.5 degrees. And that brings on the table the very difficult questions around negative emission technologies, but I won't go there today. Now, in sum, just to wrap up that first part about where the world needs to go, where does Europe need to go, what is needed are immediate, rapid, deep, and sustained emission reductions, so that by 2050, the world can reach carbon neutrality, which means a full decarbonization of the economy by reaching net zero CO2 emissions. And at the same time, we have to increase the removal capacity, especially through forests, conserving the forests we have, replanting forest areas, and also land use and soil conservation. And after 2050, as I said, the IPCC is very clearly, all pathways indicate that we need to have negative emissions, which means that removals have to be higher than emissions. This is where the world needs to go if we want to reach the goals of the Paris Agreement and if we take science seriously and act in accordance with science. Now, this was the scientific background. Now let's have a look at legislation within the European context that includes and incorporates both the Paris Agreement and the scientific findings into national laws within Europe. We have an interesting study by the Grantham Research Institute together with the World Resources Institute, which shows that within the European context, those countries that are responsible for the highest volume of emissions actually are the countries which also have the highest number of different climate laws and regulations. Most interesting within climate laws is actually the phenomenon of climate change acts that have been enacted only within the last couple of years that aim entirely and cross-sectorally at reducing greenhouse gas emissions and tackling or addressing the climate change challenge. And I just want to briefly mention 4 examples so that the audience can get an idea of what national climate change acts or laws are and what kind of measures they establish. And I give you 4 examples, one from the United Kingdom, one from Denmark, one from Finland, and one from Norway. The United Kingdom adopted a climate change act already back in 2008. That was, as far as I know, one of the first climate change acts worldwide. And that Climate Change Act set out a long-term framework to improve carbon management within the United Kingdom to help the transition towards a low-carbon economy. That act sets legally binding targets to bring all greenhouse gas emissions to net zero by 2050. This is exactly in accordance with the Paris Agreement and with the IPCC recommendations, through actions in the United Kingdom, but also abroad, for example, through carbon trading. Importantly, that act creates 5-year carbon budgets which provide a pathway to meet the long-term target in 2050. Ministers must report on the policies implemented to meet the carbon budget, and they must produce an annual report to the Parliament on the status of emissions in United Kingdom. Another aspect was that the Act established a Committee on Climate Change, CCC, which is an independent expert body to advise the government on the level of carbon budgets, of those 5-year carbon budgets, and on progress in meeting these budgets. And it's not only an obligation to provide information, it's also an obligation in the Act that the government must respond to the reports. It must respond, it has to take these reports into account, and there has to be a certain account of accountability. The second act that I would like to introduce you to is the Climate Change Act in Denmark from 2014. So it's a newer piece of legislation. In 2014, Denmark established an overarching strategic framework to implement Denmark's climate policy and the transition also to a low-emission society in that Climate Change Act from 2014. The Act establishes transparency requirements, again, reporting requirements, and public access to statutes. It sets out the direction and it sets out the progress of Denmark's climate policy. And similar to the UK Act, it also establishes an independent academic climate council. The Danish Climate Act mandates the minister in charge to submit annual climate policy reports to the Parliament, and the Parliament has to give due regard and recognition to those reports. And it also needs to set out, similar to the UK Act, 5-year targets for reaching that climate policy in 2050. The third act within the European context is the Finnish Climate Change Act from 2015. So it's a little newer than the Danish one. And the Finnish Act's aim is to reduce emissions by 80% of the 1990 levels by 2050. So it does not have a zero emission target, but it is slightly less ambitious by reducing up to 80% compared to 1990 levels. The Finnish Act includes a planning and monitoring system and measures to clarify the climate policy planning of state authorities. It provides for shorter term, once an election term plans, and also longer term plans of 10 years. The respective government is required to report to the Parliament on the implementation. And again, similar to the UK Act and to the Danish Act, also the Finnish Act constitutes of a multidisciplinary expert body to support planning of the climate policy. So in a way, those three acts are fairly similar in a way that they set a target, they create certain processes, 5-year or 10-year plans, has to be reported to the Parliament, and each of these acts establish an independent council or governing body. The final act I would like to mention is the Norwegian Climate Change Act from 2018. It's only 2 years old, which promotes the transition to a low-carbon society in Norway in 2050. So it's not a zero-carbon society, but a low-carbon society, without really explaining what exactly that entails. The Norwegian Act seeks to promote transparency and public debate about the status, direction, and progress of this work. And it enshrines the Norwegian's emission reduction targets for 2030 and 2050. It enshrines carbon neutrality target for 2050 in that legally binding setting. And the annual 5-year reviewing processes that are deriving from the Paris Agreement. So the Norwegian Climate Change Act is an implementation act in the way of the Paris Agreement into the national judicial setting or legal setting. An interesting development is what we currently see at the regional level of the European Union. The 4 acts that I just mentioned were acts in different states, but also at the regional level of the European Union, we have been seeing very strong proposals for a climate change act. You may have heard about the European Green Deal, which is an action plan to boost the efficiency or efficient use of resources by moving to a clean and circular economy to restore biodiversity and cut pollution. But the European Green Deal also has a very important climate component. And in that climate component, the EU seeks to be the first climate neutral continent in 2050. And in this context, the European Council proposed a European climate law, which is meant to turn the political commitment of the European Green Deal into a legal obligation. Currently, there is only the stage of the proposal for regulation of the European Parliament and the Council to establish that climate law. But the text is freely available, and it's very interesting to read how the European Union proposal for a climate law looks like. For example, in Article 1, which describes the subject matter and the scope of the law, it sets out that this regulation establishes a framework for the irreversible and gradual reduction of greenhouse gas emissions and enhancement of removals by natural and other things in the Union. This regulation sets out a binding objective of climate neutrality in the Union by 2050 in pursuit of the long-term temperature goal set out in Article 2 of the Paris Agreement. So that climate law takes Article 2 of the Paris Agreement, which I mentioned in the beginning of this lecture, it interprets it in the light of the IPCC assessment reports and special reports, and puts that together, puts that into the proposal for a legally binding act. Article 2 of the proposed European climate law sets out the objective of carbon neutrality, where it said that union-wide emissions and removals of greenhouse gases regulated in the Union shall be balanced at the latest by 2050, thus reducing emissions to net zero by that date. So this is a very interesting development because it comes directly from the Paris Agreement. It's included in the proposal for a regional act to make that the goals of the Paris Agreement legally binding and also reviewable, potentially reviewable by courts. And that, of course, brings me to the third part of my lecture, where I wanted to give some examples about ongoing climate litigation cases in courts within the European Union. I'll, in the very end, come back to the reflecting a little bit about the scenario, why we have this push towards climate acts, while at the same time we see a very strong push towards climate litigation. Why is this happening at the same time? But I'll come back to that in the very end. So let me introduce you or give an example of 4 cases within the European Union or within Europe that focus on climate change. And I give you 2 examples of cases that have already been decided at the highest courts in the respective states, at the level of the Supreme Courts, and then I give you 2 cases that are still contentious and not yet decided at the final stance. The first one is a case that you may have heard about. It was brought to the state of the Netherlands by a foundation which called itself Urgenda Foundation. It's a made-up word of urgent and agenda, Urgenda Foundation, which was a civil society foundation with the aim of increasing the climate ambition of the Netherlands. And the Urgenda Foundation brought that case against the state of the Netherlands in 2015, I believe, or 14, and went through the entire legal system of the Netherlands. And the Supreme Court of the Netherlands in 2019, on 20th of December, about a year ago, found that the Netherlands had failed by failing to reduce greenhouse gas emissions by at least 25%, it has acted unlawfully and in contravention of its duty of care under Articles 2 and under Article 8 of the European Convention on Human Rights. Article 2 establishes a human right to life, and Article 8 deals with the right to private life. So the case was decided in favor of the Agenda Foundation, who said that by not having a higher ambition in the Netherlands climate policy, that failure is violating both the duty of care and also the human rights of the claimants. And it was supported so in this finding by the highest court of the Netherlands, who said basically that the Netherlands need to do their fair share and that therefore raised the level of ambition from initially 20% to 25% of reduction targets by 2020. Very important case, which has been referred to worldwide and also is part of a language which seems currently to be developing between judges, between courts worldwide, where this case is very often referred to. The second case that I wanted to highlight has been decided, or was decided by the Supreme Court of Ireland earlier this year on the 31st of July in 2020. It was a case brought by Friends of the Irish Environment against the government of Ireland. And the Supreme Court of Ireland decided in favor of Friends of the Irish Environment. The case was concerned with the National Mitigation Plan of Ireland, which is the plan to implement the Climate Action and Low Carbon Development Plan. And the claimant said this plan was so unclear, it was impossible to understand what exactly the Irish government was intending to do by reading the plan. And that in itself was a violating of the Climate Act in Ireland. So the Supreme Court of Ireland quashed the National Mitigation Plan because it violates Ireland's Climate Action and Low Carbon Development Act of 2015. The court found that the plan falls short of the specificity that the Act requires because a reasonable reader, any person on the street basically, a reasonable reader of the plan would not understand how Ireland will achieve its 2050 goals. And the court explained that a compliant plan must be sufficiently specific as to policy over the whole period until 2050. So these are two very different cases, one about the level of ambition in the national climate policy in the Netherlands, the other one, how to implement already adopted climate acts in Ireland. But the point is that in both cases, the entire case went to the entire legal system until the level of the Supreme Court was reached, and the Supreme Court decided in both cases in favor of the claimants, which were civil and non-governmental organizations. Two cases which are currently still pending is one here in my home country in Norway, where Greenpeace has launched a case against the Norwegian government with the Ministry of Oil and Petroleum and Energy. That case has been heard through all three instances of the Norwegian system. We just had last week, from the 4th to the 12th of November, 10 days of hearings at the Supreme Court, but the judgment hasn't come out. The judgment is expected maybe early January 2021. Now, the Greenpeace, the claimants say that Norway, by issuing licenses to explore further areas for oil and gas deep sea extraction in the Barents Seas, that continuous exploratory activity violates the right to a clean and healthy environment, which is part of the Norwegian Constitution. In Article 112 of the Norwegian Constitution, we have a provision that sets out that everyone has a right to an environment of a certain quality, and it applies to current and future generations. And Greenpeace Norway, together with youth and older grandparents association, so we have young people and we have old people that all together supported the claim. They say that the continuous exploratory activities in the Barents Sea in order to find new areas for oil exploration violates both those children but also those older people right to a clean and healthy environment as it is defined in the Norwegian constitution. Now, the interesting thing about this case is that the constitutional provision is a very new one. It only came into the Norwegian constitution in 2014, and it has never been reviewed by a court before. It is very unclear what the material content of that provision is. And that's the first time that the Norwegian Supreme Court is dealing with that particular environmental provision or environmental right in the Norwegian constitution. So it's going to be very, very interesting to see what the Supreme Court is going to find when it issues its judgment in early 2021. And the final case that I wanted to mention is a case not at a domestic court, but at a regional human rights court, the European Court on Human Rights, where a couple of months ago, 6 children and young people from Portugal brought a claim against 33 member states of the European Convention on Human Rights, which are all the European Union member states, plus a couple of others, also including Norway. And these 6 Portuguese youth, they argue that inadequate emission cuts of those 33 states, that these inadequate emission reductions violate the human rights of those children and youth. And again, they focus on Article 2 and Article 6, right to life and right to private life, of the European Convention on Human Rights. And it's important to note here maybe that the European Convention does not include a human right to a clean and healthy environment. For example, the American Convention on Human Rights has an additional protocol, the San Salvador Protocol, which sets up that specific right in the inter-American context. But within Europe, we don't have that. The European Convention does not have a specific human right to a clean and healthy environment. So therefore, existing rights, for example, right to life and right to health and so forth, they have to be interpreted in the light of the climate challenge and what kind of positive obligations states have to ensure that those rights are not violated, including by climate change damages. Those 8 children from Portugal were claiming that the wildfires and the droughts in Portugal, which they already are experiencing, is violating their rights to life and private life. And the complainants allege that the 33 respondent states have violated those human rights by failing to take sufficient action on climate change, and they seek an order requiring them to take more ambitious action. The European Court on Human Rights has not yet decided whether this case will be admitted to the court. Usually you have to exhaust domestic remedies, but those 6 young adults went straight to the European Court on Human Rights in Strasbourg and did not exhaust national remedies. And they say it's because this claim is against 33 states and they cannot exhaust the domestic system of 33 states. It would just take too long, and that would be highly inadequate given the urgency of the task. So we see very interesting, very current developments in Europe, both with regard to legislation, but also with regard to litigation when it comes to addressing climate change. So let me round up by offering some reflections on the social role of law. Why is it so important that law is been drawn into the picture of climate governance? It's not just about economics, it's not just about technical solution, but it is about governance. And here law is a very important tool of regulation. Now we know that the Paris Agreement, as I mentioned initially, informed by the IPCC, sets very clear climate goals, very clear targets, especially the target of zero net CO2 emissions by 2050. But lawmaking is slow. We see a lot of lawmaking happening, a lot of legislation which has been adopted, is about to be adopted. But this goal of the Paris Agreement is very, very slowly being translated into national or regional law. And the backdrop of this, political action is slow. It is slow, it is so far inefficient, it is so far inadequate, and it's not yet in line with the Paris Agreement's goals, or even with national constitutional provisions. And that is where the role of the legal system and the judicial system comes in, because it is meant to hold governments accountable to their constitutions or to their national climate laws, as for example in the Ireland case. And it is also meant to hold governments accountable to their commitments under international law. For example, to interpret constitutional provisions, like in the Norwegian case, in light of international obligations, or to give a climate meaning to the duty of care, or to due diligence obligations, as in the Netherlands case, or to interpret human rights obligations, as in the Portuguese case. These are roles of judges, of courts, and they have a very rightful role to play in this context. So law, both as legislation and litigation, has a crucial role to play in the rapid, sustained, and effective transformation to a decarbonized world. And the IPCC is very clear that this is what we need. We need a global transformation across all sectors, and that rather quickly. So law is a governance tool to bring about that necessary change, that necessary transformation. And in light of the slow legislative processes and the inadequate actions that we still see, judges and courts are asked to play a much more progressive role. It's an inevitable topic. But there are challenges to judges, there are challenges to courts. I didn't have much time to go into them. One is the urgency of the task. Another one is the scientific data, which can be overwhelming, can be also difficult to assess in specific cases. There's a question of balance of power. What is politics? What is laws? But, and that's my final question, with which I would like to end my lecture. But who else, if not the third pillar of power, can counterbalance slow legislative processes and ineffective political action? Actually, these climate cases that we see all over the world, in Brazil as well, in the United States, in South America, in India, in Colombia, everywhere in the world, these might be the most important issues that judges are asked to address and to solve. Because addressing climate change and solving this is, in the words of those 8 Portuguese children that brought their case to the European Court on Human Rights, addressing that issue is an emergency like no other. Thank you very much.